friends, a very good afternoon to everyone. I think this is a perfect platform for a fruitful discussion for which we can present our views to IBBI. And I must thank Mr. Narasimha Rao from Mr. Narasimha Prasad from IPA-ICMAI. Of course, I'm also an ICMAI member. Mr. Shankar Panikar and Mr. Sean, Mr. P.T. Joy, and everyone from Kerala Insolvency Professional Forum, Mr. Manoj Anand from AIIPA. I think all of you have been at the forefront of holding such wonderful programs, updating the members and taking, you see, I know to organize any program and then registrations and other things, it's not an easy job. It's the most, and wherever you have got 4 or 5 partners, I know the job becomes much more difficult. But anyhow, hats off to all of you. I think this is a wonderful program. And we are seeing a very good attendance today also. And I think and we have already touched more than 200 now. So friends, let's start in the right earnest for what we have come here. Friends, one of the good things which I always say is that IBBI being a super regulator, I always call them a super regulator because there are 3 regulators underneath IBBI also, all IPAs. The purpose is they always issue a discussion paper before bringing out the amendments. I think that is the wonderful part. Number 2, whenever we are discussing these kind of issues, my dear friends, the discussion is that we are not scoring points over each other. We don't have to be argumentative. It is nothing like victory, but actually discussion should be for progress, that we should all combine together to give very positive suggestions to IBBI so that the changes what we want to see in the law, they should come about it. And we are also telling IBBI or the regulators from a practical standpoint that, look, whether this regulation or amendment will work or will not work, or what are the problems which we are going to face. So I think this is a fantastic opportunity for each one of us. Friends, how we are going to go about it is like this. First, as I always request, and I think Mr. Narasimha Prasad has also requested, can I request everyone to please open your videos, because I don't want to like to speak to blank screens. I would like to see all smiling faces, and maybe organizers can also take pictures of the screen so that they can also say that, look, how much was the attendance. Okay, great. Good to see each one of you. The second aspect, friends, is I'm going to share my presentation. I'm not going to speak much, but just to introduce what this discussion paper is all about, what was the background, what are the amendments proposed. I will restrict myself to giving only 1 or 2 suggestions, not much. Let it flow from the participants first, and then probably I will request the organizers also to compile all those suggestions, and I am ready to help them in sending it to IBBI also, so we can work together on that platform. So let me share my screen. I've got a very short presentation today on this particular subject. So friends, we are talking about first as a discussion paper on amendments in CIRP regulations. And of course, in the second part, we will also deal with the liquidation progress report format. My suggestion is, friends, let me complete my presentation. We will open the discussion, and after we open the discussion, we will complete the discussion on the first paper, and then we will move on to the second paper. So everyone will get a chance. You want to put your suggestions in a chat box. You want to unmute yourself, you can do that. But I would still request that if you can use that icon of hand raising so that at least the organizers know, you see that who is wanting to speak on this particular aspect. Well, as I mentioned earlier, friends, and I will also request that if everyone can mute their mics because no background noises should be there. A good discussion definitely increases the dimensions of everyone who takes part. So this is also one of the important aspects that we must, you see, take part in all these discussions. Now, friends, what is the purpose today? Naturally, we want to discuss the overview of the IBBI's discussion on the proposed amendments. The objective is this, that we need a solid feedback, and also what are the key changes which are there, typically on valuation, on representation of the class of creditors and the treatment of guarantees. And then, of course, we need to tell IBBI or the regulator that whether these are the provisions which they are proposing, whether they are going to work or not. So this is exactly what we are going to do today. So let's look at what are the key proposals, and let's also try to analyze them. The first, my dear friends, the discussion paper solicits comments on the first issue, which is registered value to submit valuation report for the corporate debtor as a whole. Now that is the purpose. What does it mean? Let's look at the few of the aspects and then we will go into the details. And the second one is that one valuation estimate for the companies up to a certain asset size and for MSME. So I'm going to take 1 and 2 together because they are talking about valuation only. Now, what is the current practice? Let's look at the current practice, friends. The current practice is that all RPs, while they are doing their CIRPs or liquidations, particularly we are concentrating only on CIRP here, they need to determine the fair value and the liquidation value of the corporate debtor. And the regulations typically require that the RP or the IRP should appoint 2 registered valuers. Of course, this has to be done within the 47th day. And if these valuations differ significantly, then a third valuer, registered valuer, can be appointed. And these are important aspects, friends. And both the registered valuers, you see, they carry out the valuation process in accordance with internationally accepted valuation standards, and then they submit a fair value and liquidation value to the RP. Now, friends, when we talk about the particular regulation, and I'm going to go into that particular typical detail also, it mentions that the RP needs to appoint 2 valuers. It does not say 2 valuers in each asset class. It does not say that. Even today, that is the existing provision, but we'll deal with it in a little while. The proposed amendment, my dear friends, talks about that we need to align the CIRP regulations with the valuation rules. This is the purpose. And they say we are going to allow a single registered valuer to conduct valuations with an option to obtain inputs from the other registered valuers or a separate valuation report if needed, as may be needed. This is something very interesting, but whether it's going to work, whether the language of the provisions which they are proposing is in accordance with what they are trying to do, I have also analyzed that, so we'll talk about that. And lastly, the second amendment, which deals with that, look, as far as the MSMEs are concerned, or a corporate debtor whose asset size is 1,000 crore. So for MSME, friends, let's understand there is no limit of asset size. Only the company or the corporate debtor has to be an MSME. The other aspect is that any other corporate debtor with an asset side of, 1,000 crores, as per the latest available balance sheet, less than 1,000 crore rupees, as per the latest available balance sheet, then of course, again, a single RV can be appointed. But the power has been given to the COC. The discretion has been given that if they think they can also go for 2 registered valuer, where only 1 valuer requirement is there. For the reasons to be recorded, they can go for the 2 registered valuers. There are certain issues on this also. We are going to talk about that. But let's look at what do you mean by alignment? Alignment of the valuation rules with the CIRP regulations. What does that mean? Friends, this is Rule 8.2 of the company's registered valuers and valuation rules. Probably everyone is aware, but for the convenience purposes, I've just reproduced it here. Look at this, what it says. The registered valuer may obtain inputs for his valuation report. The word is may. To or get a separate valuation for an asset class conducted from another registered valuer, in which case he shall fully disclose the details of the inputs and the particulars, etc., of the other registered valuer in his report, and the liabilities against the resultant valuation, irrespective of the nature of inputs or valuation by the other RV, shall remain of the first mentioned RV. So typically what it says is that, look, if a registered valuer is appointed, if he also needs inputs for valuation, for his valuation report, he can obtain it from another registered valuer, or he can get a separate valuation for an asset class from another registered valuer. Friends, if you look at very carefully, this particular clause gives us 2 interpretations. 2 interpretations are possible. Number one, that if an assignment has been given to a registered valuer, he can, while he's doing his work, he can always ask his peers or his other valuer that, okay, can you give me your input so that the valuation report is perfect? That is one part. Two, and then it says he can get a separate valuation for an asset class conducted from another registered valuer. So somebody can interpret that, look, if say one of our friends, say Mr. Manoj Anand, assuming he is a registered valuer, he is appointed to conduct for say an asset class securities and financial assets. Does this clause say that he can go to some other person and say, no, you can also do a valuation for an asset class different than securities and financial assets. So one can interpret that, look, whatever assignment is given to me, I will restrict myself only to that. Either I can obtain inputs or I can also obtain a separate valuation report from somebody else on the same asset class. Though the word same asset class is not mentioned here. The second interpretation could be that, look, a single assignment has been given. Okay, you value the corporate data, and then he appoints two more valuers. Say that person is securities and financial class valuer, and the other two for land and building and plant and machinery. He goes to the two other valuers, and then he gets their report, and he gives a final report relating to all three of them. Well, both the interpretations are possible because the clarity is not there. But IBBI believes that yes, a single valuer can be appointed. And if we give assignment to a single valuer for a corporate data, then it is up to him whether he gives his own reports or whether he obtains reports from the other sub-valuers. Let us call them as sub-valuers, and then consolidate in a single report. So this is what the IBBI feels, and therefore they say that alignment is necessary between the CIRP regulations and the registered valuation rule. So let's look at it. The discussion paper, my dear friends, what does it say? So it says, ultimately, what is the proposal and what is the benefit they are thinking? They say, hence, with the approval of the proposal, instead of possible appointment of 6 registered valuers, 2 into 3 asset class, 2 valuers may be appointed for the valuation of a CD as a whole. So this is exactly what they are trying to say, that instead of 6, assuming if a company is more than 1,000 crore asset base, so they say appoint only 2, don't appoint 6. Appoint 2, let you give the responsibility of appointing the further asset class only to that registered valuer, and the RP will not be bothered about appointment of that. Now, let us compare, my dear friends. Existing regulation 27 and the proposed regulation 27, I think things will become clearer. The language, if you read under both, my dear friends, they are on your screen. The language is exactly the same, except on the 2 parts, which I have also put in the bold. Number 1, the existing regulation 27 says the RP, of course, shall within 7 days and but not later than the 47th day of the ICD appoint 2 registered valuers. Does it say 6? Does it say 6 valuers? It says 2 registered valuers to determine the fair value and LV of the corporate debtor in accordance with regulation 35. Let us go and see what is being proposed. So proposed is that RP will appoint, now they say appoint registered valuers. So 2 is gone now. So they are simply saying appoint registered valuers to determine fair value and liquidation value in accordance with regulation 35 as under. So as under words have now been proposed to be added. So remember, friends, this is very important. Even earlier, regulation 27 talked about appointment of 2 registered valuers. It never said each asset class. The word was missing. And even the new one also, regulation 27 proposed, the asset class word is missing. So it simply says appoint registered valuers as under. Now, what is as under? Let me show you what is being proposed. Now, this is the full new proposed amendment, that is regulation 27. So 1 we have already read. Let us read A now. As under means 1 registered valuer in case the corporate debtor is MSME under section 7(1) of MSME Act, or its asset size is up to rupees 1,000 crore as per latest available balance sheet. Right? And then it says, provided that the committee may decide with reasons to be recorded to appoint 2 registered valuers. And then it also says in the same breath, 2 registered valuers in case other than those covered under sub-regulation 1A, which means if you are not an MSME, if your asset size is more than 1000 CR as per the latest available balance sheet, then naturally you will have to appoint 2, but you have an option to appoint 1. And then the committee COC may decide with reasons to be recorded about the appointment of 2 registered valuers. Mr. Girish, just give me some time. Let me complete this and I will come back to you. So keep raising your hands, friends, and I think so that we can discuss one by one the amendments which are being proposed. And we would want to understand the practical aspects typically on this. Now, friends, para 1.6 of the proposed amendment also says that RV may conduct the valuation as per Rule 8.2 of the valuation rules, taking inputs from other asset classes or get the valuation for an asset conducted from another registered valuer if required. So this is exactly what is being proposed. I mean, what is the basis of that? I've already shown you Rule 8.2 of the valuation rules. Now, friends, few of the aspects which are coming. Let us try to understand this way. Number one, I just showed you, and I think let me go back once again before I take it up. Look at this. Existing regulation 27 also mentioned appointment of 2 registered valuers. And we already had Rule 8.2 of valuation rules. Why we were appointing 6 then? We could have appointed only 2. It was possible. So what is, I'm really trying to understand, of course, the objective is nice, which is written in the para 1.5 on the left-hand side of the screen. That is fine. That today, instead of, because we need to align. So they were already aligned, according to me. There is no change which has happened. Only change which is happening is that you are giving an option today for an MSME or an asset base of less than 1,000 up to 1,000 crore that you can appoint 1 valuer instead of 2. So, but in other cases, it still remains 2. So where does regulation 27 say that you have to appoint for each asset class? So I don't find any difference between the existing regulation and the proposed regulation. See, the objective of writing this discussion paper may be fine, but I'm not seeing any difference, my friends, because earlier it was 2 registered valuers. Today it says 1 or 2, which is the option. So friends, I think I'm not really, understanding that what exactly is happening here, because valuation rules 8.2 were still there. So regulation 27 of CRP read with valuation rules 8.2, we could have also appointed only 2 valuers. Why we were appointing 6? Let the other one could have done it as per the rules. So today, I don't know what is the change they are wanting to bring in. So that is what, of course, they're written in the discussion paper that instead of 6, we would need to appoint now 2 only. So, but ultimately 2 means that the 2 who are appointed, they will appoint 2 more. Supposing if the company has to get valuation for all the 3 asset classes, naturally there will have to be a different valuer for that. So I will appoint only 1 and he in turn will appoint 2. And if I appoint the second one, he or she will in turn appoint another 2. So that same thing is going to happen. So this is one of the things. Now let us look at, my dear friends, the pros of the proposed amendment. Number one, they say that this will align, the simplify the valuation process and potentially reduce the number of the valuers required. According to me, it is not going to reduce the number of the valuers. In fact, if I appoint, of course, in case of MSME, yes, instead of 2, we are going to appoint 1. So the number of valuers are going to get reduced or up to 1,000 crore asset base. But insofar, if we appoint 2 and in turn they appoint 2 more each, so typically the number of valuers will remain same. That is one. And second, of course, if we bring out the number down from 6 to 3, right? Because now we are going to appoint only 1 valuer who in turn may appoint 2 more. Then naturally the number of valuers are being associated, which are being reduced, and then it will also reduce the cost. That is also there. The third, which the IBBI says, is they are aligning with the regulation, reduces inconsistencies. I have my doubts. My dear friends, where the same position existed in existing regulation 727. Now again the same thing is there. So why we were appointing 6 under the existing regulation? So this is one of the things I think we need to really look into it. Then what are the disadvantages? Of course, we are going to discuss. I'm just giving you on a broad one. Number one, the risk of inaccuracies. Now, typically, what was the purpose of appointing two valuers was that we must have a comparative. One person can adopt a methodology which may give a higher valuation, the other one may give a lower valuation, and that is why there was a reason. There was a provision saying that, look, if the difference between the two valuations is more than 25%, then there will be an option of to appoint the third valuer also. So typically, the risk of inaccuracies will always remain, because if we appoint only one valuer, we don't know what is going to be the second valuer, unless COC typically decides. So dependency on the sub-valuers. Naturally, a valuer will have to appoint certain, other sub-valuers. So he will also rely on their inputs, which may lead to some inconsistencies or delays, or maybe things can happen. And then, of course, one valuation may miss discrepancies that two valuations could cover. That is reduced checks and balances, because it was typically a checks and balances. Now, friends, let us look at the comments on one by one, and I'll show those proposals, the issues, and then we will invite comments on that. Number one valuer in each class instead of two valuers in each class. I think we must give our comments, give our suggestions on these. So we'll start with Mr. Girish and then Mr. Vikram Kumar. Yes, sir, you want to say something? So please unmute yourself.
Yes, sir. Thank you for allowing me to give my point of view on this. I'm particularly uncomfortable with the fact that COC is in a position to decide whether we need additional valuers, because the valuation numbers are not, it's supposed to be confidential from them till the time I think information memorandum is prepared.
Okay. I think what you are saying is already covered in my slide. In fact, it was coming little later. So the involvement of COC in appointment with a question mark.
Correct.
I already mentioned that. Yeah. But anyhow,
it's supposed to be confidential, and only criteria which I see is valuation is not satisfactory, and then COC can say your valuation is not good. It is not giving the true picture of the assets. So I need another valuation to be done. But then they don't know the valuation numbers.
Yeah. No, Mr. Girish, let's all try to understand. The proposal says, and that is a very good point which you are raising. Number one, it is always a duty of the RP to appoint, within 47 days. So within 47 days, the COC may or may not be appointed. We don't know, because there are certain delays in some cases, right? And then for appointment of valuer, now I'm going to COC for approval. Earlier, I've seen disciplinary cases from IBBI where a valuer was not appointed because COC did not approve it, and IBBI held that IP guilty. They said, why did you go for appointment of a valuer to the COC? COC had no power to appoint. Today, now we are turning the clock back and we are saying that, look, let us go to... So in every case nowadays, I think the RP or the IRP will have to approach COC first. That whether you want one valuer or whether you want two valuers, in case you are an MSME or asset basis up to 1,000 crores. If it is beyond 1,000 crores, there is no doubt you have to appoint two valuers. So this is involvement of the COC in appointment of the valuers is I think something which needs to be looked at. That is one. Two, in those cases where no COC is found, supposing no claim comes, I've seen many cases where nobody is filing a claim. So will the RP or IRP not appoint the valuer, or formed late? Supposing it is formed, say, on the 100th day. Sometimes the delays may happen, isn't it? And then the second part, which you also mentioned, that if I don't like the first valuation, I can go for this. Now, that is a point. In fact, if you ask me, the provision which says, let us go back to, say, the new provision, what exactly is the language? Let's read this. Provided that the committee may decide with reasons to be recorded to appoint two registered valuers. So the question that arises is, do they have to take a call before the appointment or after receiving the valuation report? According to me, it is before. So now that is why I've also posed a question. I'll go back to those questions once again. Let us look at this. Whether COC can revise his decision later. That's what I'm trying to say. Supposing today they decide one valuer should be appointed and the RP goes ahead. And once the valuation report comes and they say, we are not happy, let's revise our decision. Can they do that? It is definitely going to delay the whole matter. So this is also another important part, because the regulations very clearly said earlier that if the valuation is 25% different than the other, only then you need to appoint the third one. Otherwise, there is no need to appoint beyond the two which were there. But today, if you are appointed one, will it be okay? Or COC can tomorrow say and tell the RP, no, we are not happy with this valuation report, take another. That is another question which needs to be asked. Yes, I think you
At
point.
what point of time this question get triggered? I think it will get triggered when the resolution applicants submit their proposals and etc. Correct?
No,
Till that time the COC doesn't know the valuation, right?
Yeah. No, the point is, this is triggered, my dear friend, prior to the appointment of the registered valuer. So whether COC will have to take a call or two. The only question is whether they can trigger it later on also. That is the question. Because the regulations do not permit that, but that is silent on that. Good point, sir. I think we'll take a note of that. Yes, Mr. Vikram Kumar. Yes, go ahead, sir.
Yes, sir. So, sir, basically, what Mr. Girish said, my view is that basically, the RP shares the valuation with the COC only post receiving the resolution plan. And normally, the banks also have a valuation done prior to the CIRP of any assignment. So, I think, post the resolution plans have come, and when the RP shares the first valuation report, the COC might say, I want another valuation to be done. So that is only possible when the resolution plans have come, and that is not 47th day. So
True.
I have my doubts. Can the RP appoint a valuer at say 150th day or 120th day when the plans have come?
I think that is not the purpose, sir. If I look at the language, this is what we were discussing. Look at this. They say the resolution professional shall appoint within 7 days and within 47th day one valuer, but then the committee can decide. So therefore, they have to take a call at the time of the appointment, not later. So according to me, if the valuation reports are opened on 150th day and then the COC says, no, let us appoint the second one, I'm sorry, I don't think that is the provision. Provision says you take a call whether you want to appoint one or two at this stage itself. No later on thinking.
So, sir, can we take?
Clarity is not there. But the clarity is not there. I agree with you.
So can we take it as by 47th day the RP has to take a call and appoint one or two valuers?
And go to COC. Not only take a call, go to COC, get their approval for appointment.
So beyond 47 days, RP cannot actually go to COC and seek appointment of another valuer, even if the COC wants to appoint another valuer.
No, all this is, of course, the time limits, whether they are discretionary, directory, or mandatory, that's a separate aspect, because valuers are being appointed even after 47th day in certain circumstances. You have to give reasons for delay. So I'm not on the time limit. All I'm saying is that COC has to decide prior to the appointment of the valuers. Once the valuer is appointed and their report comes and then they say, no, now we want to appoint the second one, that may not be possible. This is not what I'm reading from these regulations.
So two more points. Now, up to 1,000 crores, we have to appoint one valuer. So I believe 95% of the cases are up to 1,000 crores. In a CIRP, almost 90% cases will fall within the bracket of 1,000 crores. So I think,
one valuer only,
Yeah, so I think valuers will have a tough time in getting assignments.
That is for the valuers to object, not for the RPs to object here.
No, and just
if you are wearing two hats, then it's a different.
Many of the RPs are wearing two hats, sir.
And sir, the last point, sir.
Yeah.
There is a regulation, proviso to regulation 35(1)A, which says that the RP shall facilitate a meeting between the registered valuers who shall explain the methodology to the COC.
Correct.
Now the point is, if suppose I am the SFA valuer and I have been appointed as the valuer, how do I explain the methodology for plant and machinery and building?
No. Then in that case, so that is quite administrative. Then I'll bring my team. I will bring my other sub-valuers also who will explain. So that is all right. That's not a problem, because in any case, I'm relying upon the sub-valuers to get the valuation of plant and machinery, land and building. Naturally, they will be part of my team. They will come to COC and they will explain the matter. I don't foresee any difficulty there.
So, sir, is it basically meaning to say that only registered valuers entities should be appointed, or even a registered valuer can be appointed?
No. Even a single registered valuer, like if you are a registered valuer, Vikram Kumar can be appointed. He can approach two of his friends or associates or whatever. I mean, the independent valuer. So that's also another question. Let's go let's look at the questions and then we can open the discussion. Number one valuer in each class instead of two valuers. Do we have objections to this, except for the fact that it is reducing the work for the valuers? That is one part. Two, the word which is used is, I think I need a little more clarity. It says MSMEs under Section 7, subsection 1. Friends, I think all of us are aware, Section 7 of MSME Act talks about classification. It gives only a classification criteria. Section 8 talks about registration. So is it only classification? Because they are using the word subsection 1 of Section 7. So I'm only presuming it is classification, not registered. So do we insist for Udyam registration? And supposing, and then it is also going to bring in a lot of issues. CIRP starts, the company is classified as MSME, not yet registered, assuming there is no registration certificate. Can RP get a registration and can he say now it is an MSME? So I think we need some kind of a clarification on this, because if they are using the word classification from a legal perspective, whether I'm registered or not, it does not matter. It's only simply I should satisfy that criteria of classification. So I think another aspect is we need clarification. It should be clarified when we are bringing in new regulation, we should bring it more clarity. The third point which I've mentioned is CDs which have assets more than 1,000 crore. 1,000 crore or it should be 500 crores, we can debate on that. But I have also another aspect comment to make. It says as per last available balance sheet. Now, what do you mean by last available balance sheet? Supposing the company comes into CIRP in 2024, the last available balance sheet is of 2019. Supposing no balance sheet has been done. So will I rely only on 2019? Maybe in 2020 or 2021, the company might have purchased 1,000 crore worth of, as you see, more assets also. We don't know, but as per the balance sheet, old balance sheet which is available, it is there. And two, whether it should be, when they're using the word available balance sheet, I think they should say audited balance sheet. Because a balance sheet available can be provisional, can be as per books of account also. So I think we need more clarity as far as the last available balance sheet. So and they should also put in a benchmark that it should not be older than 1 year or maybe 2 years older. Let's do that. Otherwise, it's going to create a lot of litigation, a lot of issues which are going to come. Then the other point is that supposing I appoint one valuer, he in turn appoints two more valuers. Who will decide about their fee? Whose responsibility it will be? Of course, Rule 8 says ultimate responsibility will be of the front registered valuer, not the back end people. But still, I think we need more clarity. Can he appoint related parties? Who will do a check? Supposing I am a valuer and I appoint my brother as a valuer for land and building. Will that work? Again, you see, we are trying to monopolize, because somebody talked about, you see, the entities, RV entities. So are we trying to monopolize the situations? Then what about independence of those people? What about disclosures requirement? Now today, as an RP, supposing I appoint 6 valuers, I always get a disclosure from them. But if I'm appointing only 1 or 2, then do I need to get disclosure only from these 2, or I need a disclosure from sub-valuer also? This is not clarified. So this is another issue which can come up. So let's look at the other points also, then we'll take suggestions. Then involvement of COC in appointment, I think we have already discussed.
Sir, sir, I'm interrupting. I have a simple point. What is the lacuna in the current provisions? That has to be highlighted by the IBBI also. You are changing right now a provision. If you have noted some lacuna, then you are applying into new provision. That has to be clarified also. What they found wrong.
Sir, the lacuna is, of course, as far as appointment of 1 or 2 or 6. I also mentioned to you that I don't find any difference between the existing regulation and the proposed. That is there. The only change is that they are wanting to reduce the burden for MSMEs, number 1. Let's try to understand that way. And 2, up to 1,000 crore asset base. So they are saying instead of 2, appoint 1. That means instead of 6, appoint 3. So let's believe that. When I say 1, it doesn't mean 1. It means 3 actually, if you have all the asset classes which are there. And let us look at the last point, and then we will, the clarity of language. You see, where does it mention asset class in existing or proposed? I think I've already shown you that. So let's have more suggestions, friends. I think Mr. Amit
So
Kumar
100 crore is
there
gross value or net value?
1,000 crore asset base they have written.
So is it gross or after depreciation?
No, it says as per the balance sheet. So in balance sheet, I will presume after depreciation only.
But I think,
But
if it
it doesn't
is
say so. You are
clarified,
right. You are right. It doesn't say so. So I think we need to have a suggestion whether it is a gross value or a net value. Good point, sir.
Sir, if assets value is 1,000 crores as per available balance sheet, what is the present condition of the assets, sir?
Acha, just
500 crores or less than
Sir, yeah, Mr. Venkata, can you just give me a moment? I think Mr. Amit Kumar Goyal has been waiting very patiently. I'll come back to you, sir.
Yes, sir.
And then Bharti ji, and then please you can come in. Yes, Mr. Amit Kumar Goyal. Okay, I don't think he's able to unmute himself. Yes, Bharti ji, you go ahead. You have to unmute yourself. Yeah.
Yes, sir. Hello, sir. Good evening. What I was asking was that when you say that the asset value is 1,000 crore, according to me, when I say SFA, plant and machinery and land and building, it is the total of the debit side of the balance sheet, or the total of the asset side of the balance sheet is 1,000 crore. Why do we only see the depreciation value or something like that? It should be the total value of the balance sheet, right? Because it's asset, total asset is including of the financial assets, the land and building, plant and machinery, loans and advances, everything.
No, see, there are two things. In the balance sheet, typically speaking, what is reflected is always the net value after depreciation of the assets. I think you are aware. But we always have a fixed asset schedule, which indicates the gross value and the depreciation up to this date, accumulated depreciation, and the net value.
Correct.
So
No, I'm not disputing about that. I am saying that when we have to look at the 1,000 as a figure, it should be inclusive of the assets of the company, which is the land, building, plant and machinery after depreciation, obviously, then the loans and advances, cash bank balance, and the other assets, including, it is actually the bottom of the asset, the total asset of the company, irrespective of the depreciated value or not depreciated, because the balance sheet, when we calculate the asset of the balance sheet, is equivalent to the liability also.
No, that is not the correct proposition. I don't agree.
Actually,
So why don't you agree?
let's not. See, that is what I mentioned in the beginning. We're not attaining for any personal victories here. We are trying to talk about. Because your point is well taken. Your point is well taken. We will
also one more question was there, sir. When we are talking about the valuation, and the valuer can take the support of the other valuer for writing his report, but as per the regulations of the valuation, of the rules of the valuation, the valuer will be responsible for the statements taken by the other valuer in his report, if he's putting it in his report.
Correct.
So in that case, if I take, say, if I am taken as a valuer of a company which has got assets as plant and machinery and SFA, for example, maybe plant and machinery may be a very small part of it, but it still forms part of it.
Yeah, and you are taking responsibility. Yeah, you are taking that is as per rules. So
I am taking the responsibility of the valuation of the third party.
Naturally.
So don't you think that would also be a little discussion point?
No, Bharti ji, then that is not a scope of discussion here. That is a scope of discussion in valuation rules. Then IBBI has to amend those rules, or MCA has to amend. Rules are made by the MCA, not even by IBBI. Let's not debate that. The question is, naturally, somebody has to take responsibility. Now, if you are at the front end, you are submitting your report under your letterhead, but it is being supported by two more documents. Obviously, those valuers will also be held responsible. Supposing tomorrow some disciplinary case comes on valuer, naturally, those will also be liable. But the front end person will naturally will be liable first. So that is what is there. Okay, so friends, I think what Bharti ji is saying is asset size. Now, asset size, they have not clarified. Should we only include the land, building, plant and machinery, and securities and financial asset, or maybe some other assets also? So that is what. But if you ask me, if we add up plant, machinery, land and building, you see, and securities and financial assets, then exactly tell me what is left out. The combination of all these three will be the total assets, isn't it?
Intangibles, sir. Intangibles.
Intangible could be there, but intangibles are also to be valued.
Has to be valued.
They has to be valued. Only problem is the accumulated losses which are appearing on the asset side. So probably they have to be included or excluded. That answer has to be required. So I think we can also put that suggestion to IBBI. A good point, sir. Yes, I think Mr. Venkata, you can now come in, sir. Mr. Venkata, if you are hearing me. Mr. Sudhakar Rao. Yes, sir.
Same what Bharati madam says, that is my view, sir.
Yes,
what
sir.
about the present question of the assets and their value and
Right.
value, basing on that only we have to proceed. That's why what
Right.
madam said is correct, sir.
Right. So one is whether it is a gross value or a net value, then what happens to the entire asset side, or what assets to be included and what assets not to be included.
Yes.
Good point, sir. We'll take note of that. We'll definitely submit it to IBBI. Yes, Mr. John.
No, the point I was about to say, which you already touched, whether it, asset means whether it is fixed assets, all the assets put together. No, see what is appearing in the balance sheet.
Right.
You just touched upon that.
Yeah. I think it typically has to be all the assets. It can't be only we cannot pick and choose when we say asset, because they are also using the word asset. So asset means the total assets typically. Yes. Yes, Mr. Panikar, please go ahead, sir. You have to unmute yourself, sir.
Sir, when it comes to one valuer in each class, meaning the RP has to appoint only a one valuer. That means that particular valuer will get in touch with other valuers and get given. Now, what happens here is, definitely this is going to be a, as madam said, clash of interest. But here, this is, we have to articulate in such a way that I've seen n number of cases where even if it is a resolution passed and it's being challenged before NCLAT saying that the valuation is wrong, this is substantially low valuation and descending financial creditor and all those things. That's number one. The one thing which I feel that some feedback has to be given, because here the RP's response, RP has to answer all the queries which is being shot at him at the NCLT adjudicating authority, as well as the, why you have, what is the, he has to give a or a declaration or affidavit saying that format and everything is, complied with. So that is one thing which I feel that this is going to be very, very dicey. And number two, sir, is when it comes to classification or MSME, there I've seen a couple of case laws wherein one case, Honorable NCLT says, no, this registration has been taken by RP, it is not valid. Whereas when it comes to Udyan, they have agreed to. So therefore, there has to be a clarity with regard to MSME at the date of insolvency commencement date, because as an officer of court, even though we say the going concern and all those things, but RP, if he takes a Udyam registration during his period, I think that is against the principle. There is a, he cannot be like a, somebody.
Sir, on this aspect, I may clarify that number one, there was a confusion because of the NCLAT judgment that, look, the MSME status should be on the date of insolvency commencement date and not later. But now the Supreme Court has clarified, which is clearly mentioned, that at the time of the submission of the resolution plan, if the corporate debtor is MSME, whosoever takes the MSME registration, it does not matter whether RP or whatever, and naturally RP will take once the ICD begins. So that has been clarified. That aspect is clarified. That if the MSME status is there on the date of submission of the resolution plan, it is valid. So it does not matter who takes it. So that judgment is gone now, which said that no MSME status on the date of ICD has to be seen and not later. So that judgment has been overturned by the Supreme Court. Anyhow,
even though it's a Supreme Court, there's a Supreme Court judgment, but don't you think, sir, it is good to be part of regulation or the act? Otherwise,
the point. You see, look at things. Look at PPIRP. What does it say? It only talks about classification. It doesn't talk about registration. Even this provision, regulation, also talks about classification. They are referring to section 7.1, not to section 8. If that was the intent, why did they mention 8 then? That registration is mandatory. In fact, at the stage of PPIRP also, this problem came, and I in a number of webinars, I said, look, I will not ask for registration. It is only merely a classification that is mandatory as per the forms also. If you look at the PPIRP forms, and IBBI agreed to that suggestion. So today also here they are only talking about classification, according to me. But I think we should put it up to IBBI that whether classification is the only requirement or you want registration also. So both the things should be there, because typically, yes, you are right. Some courts or NCLTs insist for Sudyam registration. Okay, then unless you are registered, you are not an MSME.
Most of the cases, this entrepreneurs will come back, MSME, they will come back, all those things.
They will come back, right.
For sure, I've seen a lot of cases where the
Right.
director says, no, this number is wrong. Bankers say, we have given loan based on that number, that valuation. This is wrong.
And it's a complicated calculation, because you see in calculation of the asset of whatever value, I think there are a lot of exclusions as per one of the circulars. Like the installation cost, all these things can be excluded. So who can do that? RP cannot do that, because RP doesn't have those figures you see available with them. Good point, sir. Yes, Mr. Parthasen. Sir, you need to unmute yourself, sir.
Sir, I have 2 points here. So firstly,
Yes,
sir, the proposed regulation says that the RP will appoint further valuer will appoint further valuers if he thinks so. So, sir, can it be from his own entity, valuation entity? I mean, you rightly
Sir,
said that related party is not clarified, but
okay.
I am open to appoint from my own entity.
Okay, that is one thing. Look at the regulation, sir, proposed regulation.
Yeah.
That one registered valuer has to be appointed in case of this thing. So you are appointing one valuer, right? Now,
RP appointed one valuer.
RP appoint. It doesn't say
is open to yeah.
So it does not say that this valuer will appoint 2 more. There is no clarity, right? This is also another part of it, which is important. Okay. Because at the end of the day, you are absolutely right, which we have already covered these 2-3 points in my slides itself, where we are talking about independence. Look at the last one, sir, here. Look at the last one. Just a second. So where it is, yeah, look at this.
Yeah.
Independence. I mean, that is what I said. Supposing I am an valuer entity, or say, so I can appoint my friend, I can appoint my partner, yes. I can appoint any person. So what happens to the independence? What happens? Who takes disclosure? Whether related party or not. So I think those checks will still be there. But I don't know whether those valuers will be bound by that or not. There is no clarity insofar as that is concerned. You are right, sir. Your point is noted. We will definitely, put it up to IBBI to clarify on all these aspects.
My next point is, since this has already been issued as a discussion paper, can COC take the plea? Okay, we don't allow you to appoint 2 valuers.
Yeah, so one is, we are very clear, sir, as per the regulation, according to me, from a legal perspective, COC has to take a call at the time of the appointment, whether they want to appoint 1 or 2, if the option is available. If naturally it is more than 1,000, there is no option. But what happens if they take a call after? Like Mr. Vikram Kumar said, when I'm opening the valuation reports on a 150th day, giving it to the COC, and now COC turns back and say, please appoint the second one, this is going to come in litigation. So I think we need clarification that COC will not have any power to appoint another valuer after that.
No, sir, I'm talking about the ongoing assignment. Can COC take plea? Look, already discussion paper has come, so you don't allow to appoint 2 valuers.
I think typically speaking, these regulations apply prospectively, not retrospectively. So in a case where is an open case where valuers have not been appointed, probably this may be applicable. But where you have already appointed valuers, I don't think that COC will be open to open a Pandora box in this. But yes, your point is valid. I think we must ask for from which date these provisions are applicable. Whether the CIRP starting on or after this date, or even for the CIRPs which are ongoing. Good point, sir. I think we'll note it down. And maybe put it up to IBBI. Yes, friends, any other point which you would like to discuss or share your suggestions or comments? 1 valuer instead of 2 valuers. Whether MSME, CDs, assets more than 1,000 crores as per last available balance sheet. I think we have already covered that point. Whose responsibility of fee, related parties, independence, disclosure, no clarity out here. So I think these are the points. Yes, sir.
Sir, if possible, can we reduce from, can we suggest that this 1,000 crores will be reduced to 500 crores or something like that?
Okay.
Is-
Any logic for that, sir? I mean, of course, but there has to be certain benchmark. Of course, we don't know what is the benchmark for 1,000 CR, but I'm just asking you, what is the benchmark for 500 CR?
Presumption is the fact that the company going into insolvency cannot be that having assets of 1,000 crores. I'm saying the dirty dozen is no more available now. And what I'm saying is lesser risk, because when it comes to resolution plan, you get the resolution applicant, end of the day, haircut is the order. So therefore, it should not be given to a bigger base. You know, it should be. And also,
So you are suggesting 500 CR instead of 1,000 CR.
Yeah.
Okay. I think I tend to agree. I tend to agree with you because for a very simple reason, because even 500 crores is a large base, right? So naturally you need two valuers beyond a particular point, because if the valuation goes wrong of an asset of more than 500 CR, then who is going to, because a maximization of value will get affected, right? Isn't it? So I think it's a good point. We can suggest to IBBI anyone who wants to comment about 500 CR or 1,000 CR. Yes, Bharti ma'am, go ahead.
Mr. Makhija, I also agree with the comments. But one more thing, just want to add in it, as they have been rightly pointed out, the value of the assets 1,000 crores. So in IBC, we have seen the cases wherein there is no balance sheet for past 4 or 5 years, and at that point of time, the assets were more than 1,000 crores. But now, at the time of initiation of CIRP, it reduced to 200 CR. So unless and until we get the valuation or get the balance sheet accounts ready, it is not possible to have the valuers appointed. And who will decide, because of no data, how could we draw a balance sheet with a 200 crores or 300 crores assets value?
True. I think we all agree with that point. What you have pointed
Also
out is,
here, sir, my submission was that if the company size is this big, the first person to know that the company is going into insolvency is the promoters and the directors of the company. We've seen many cases where the assets have been sold off, because the balance sheet that I must have filed in the MCA, which I will be getting the latest, would be at the time when everything is very rosy. And after that, I stopped filing the balance sheet because I have done a lot of mischief in the balance sheet. And maybe the assets which are shown in the balance sheet as on the last date of the filing, we will have nothing as on the date of the...
We have seen many cases where debtors are written off and we file avoidance application.
Yeah,
You are right.
exactly.
Right.
Yeah.
I think those clarifications are required. Good point. Good point. Yes, I think, I don't know, IBC laws. I don't know the name exactly. Yes, sir. You go ahead, sir. You raise your hand first.
I have, sir, another suggestion. Just like IBBI proposed some, minimum. Yeah, sorry.
Sushil, can you just wait? There are some people who have already.
Okay, sir. Sorry.
So we'll come back to you. Yes, sir.
My name is Shivaraman, Kashi Vishwanathan Shivaraman.
Yes,
This is with regard to why this confusion to be brought in, sir. Instead of straight, you can say you can appoint 6 valuers with asset classifications done in such a manner so that there is clarity, more clarity in this, rather than 2 valuers and then getting the valuer to do his own job of getting other people. It is not required as per my suggestion. It is better to say land and building, plant and machinery, and SFA have to be valued by 3 different valuers of 2 sets. Finish, matter is over. There ends the matter. Why you create so much of confusion? Asset base, ye karna, wo karna, kyun? Why should we? The law should be very simple, sir, as far as I am concerned, and the regulation must be very simple. It should not be complicated. That is what is my suggestion, sir.
Absolutely, sir. If the law would have been so simple, no discussion paper would have come.
No, I'm not like that, sir.
We will take your point, sir. I mean, just in a lighter way, I mentioned.
No, I understand that. I've understood, Mr. Makhija. That is not an issue. But what I'm trying to convey is too much of confusions. Already there is a lot of confusion in IBC law. Still you are adding some more thing to the fire. Fuel to the fire.
So Instead of simplification, in fact, I always wondered why simplification is such a large word. I mean, a long word. Okay. Yes, Mr. Yogender Singha. Yes, sir. Go ahead, sir.
Makhija ji, actually the existing regulations are very fair because the valuation is required on a fair value. Only the two valuers can decide the fair valuation. Overall, the responsibility of the RP or IRP, no responsibility on the of the COC or the IBBI, who is proposing the amendments. Overall, the RP is responsible. Whether if in the opinion of the RP, the two valuers are to be appointed, but the amendment is proposing only to appoint the one valuer. So overall, the responsibility of the RP, whether the RP can clarify at the time of appointment,
Okay.
or the COC is responsible or not, because overall RP is responsible. The
So
existing regulation is very sufficient.
Yeah, RP will continue to have control. If you appoint directly the people, then RP can control and can have a good discussion with them. But if a valuer appoints a valuer, he may lose certain kind of a control. That's what you're trying to say?
Makhija ji, overall the responsibility of the RP, not of the COC.
Understood, sir. Understood, sir. Understood. Understood.
The
So
RP,
even
the RP position is to be cleared in the regulations. If one valuer has manipulated the valuation, then who is responsible?
Okay. Okay. Understood, sir.
It is
Good
to
point.
be clarified in the.
Good point. Good point.
Because
That's what I said. That is what I said, sir. The ultimate responsibilities of the RP. If he does not retain control over the appointment and the methodology or what, I mean, he can't control methodology, but at least he has a direct discussion with all the valuers, right? But I don't foresee any point. Look at this scenario. Supposing you are appointed as a valuer, you appoint two more. Naturally, No, just listen to me, sir. Supposing that those two new valuers who are appointed by this valuer, they can also get in touch with you. So the question is, they can still ask direct questions from you. Anyhow, your point is well taken. We'll consider that in our suggestion. Yes, Paraji, go ahead.
Sir, looking at the scheme of these regulations, is it clear that COC will have only right to approve or reject? They cannot recommend name of registered valuer.
Well, that is also not clear. You are right. Whether supposing that means what you are saying is, supposing you say that I'm going to, no, I think according to me, if you look at the regulation, they are only taking a call whether you have to appoint one or two. They are not discussing names here. The names are not to be approved. Simply,
because otherwise it will be a problem of independence of RV.
Yeah. So naturally, so therefore they are not saying, they are not getting into that. But yes, if you go back to them, they can get into that also. Okay, disclose the name of the valuer whom you are appointing. Because if we are appointing one, he should be of a credible nature, isn't it?
Yes.
Then COC may come in and say, no, this man is not credible. You appoint this large firm. Well, you are right. To that extent, I think that needs clarity on this. Okay, we need clarity. Good point, sir. Okay. Friends, if there are no more comments on these two aspects, let's go to the third one now. The third one is talking about the voting by the authorized representative before appointment by the adjudicating authority. I think, friends, all of us are aware that in case there are creditors in a class, right? Then we need to appoint an AR. And how the AR is appointed, I think everyone is aware of this fact that RP suggests three names. I mean, he takes consent from the three IPs. Then in the public announcement, he mentions the three names. While filing the claims, those class of creditors pick up one name out of that, and the person who gets the maximum number of votes, naturally, he is appointed. He is selected, not appointed. He is selected as an AR, and the RP moves an application to the adjudicating authority. And then once the adjudicating authority approves it, then the person is said to be appointed. So the question here is that there can be a certain delays which can happen. This is what exactly is written in the discussion paper. The delay in the appointment of the ARs can prevent creditors in a class from being represented in COC meetings. Because supposing one COC meeting, naturally, he has to be appointed before the first COC meeting. But sometimes the applications are getting delayed at the stage of adjudicating authority. the meeting has to be called. So then who is going to represent the class of creditors, particularly in case of home buyer? So that is the question which the IBBI is raising here. Let us look at what is the proposal and then we will have a discussion. Allow the interim AR. In fact, they have not used the word interim AR. I'm using that word. In fact, they have said IP who will continue to be as in interim. So what they are saying is, supposing out of 3, 1 IP gets the maximum number of votes. Now, naturally, that application will be made to the adjudicating authority, but while it is pending, IBBI says that person who gets maximum number of votes should be entitled to perform his duties, continue to be performed as duties as kind of interim. So I will use the word interim AR, right? So interim AR typically will be using their powers, and they will also be exercising all powers and duties and representing the class of creditors in all COC meetings till the time his approval comes. So typically they are bringing out a new concept of interim AR. Well, this is the proviso which they are going to insert on regulation 16A, provided that the IP selected under sub-regulation 1 to act as AR for a class of shall be entitled to attend the meetings of the COC and perform such duties as provided under section 25A from the date of submission of application for his appointment as AR to the adjudicating authority till such date of his confirmation by the adjudicating authority. So this is the proposal, my dear friends, proposed amendment which is there. Well, the benefits of this is that there is a continuous representation, so creditors are not left high and dry, they are always represented. Then there is a creditors' rights are also protected. So this is one of the benefits. What are the potential legal challenges which I can foresee? Of course, we will be opening for discussion also. Number 1, whether the regulation, which is a proviso which they are adding under regulation 16A1, whether it can supersede 21(6)A and 25A. In the act itself, the word used is authorized representative. There is no concept of interim AR. There is a concept of interim resolution professional, IRP, in the law itself. And today we are trying to bring this through a backdoor, through a regulation. I don't know how far that will be valid. As far as appointment of the interim AR, I have my doubts. That is 1. Number 2, now, if the interim AR takes actions, right, because he's still not confirmed by the adjudicating authority. Now, what happens supposing if the AR rejects his appointment? Typically, they will not. And we have not seen any case where the AR appointment is rejected, but there can be a chance that his appointment is rejected. Let's look at in a theoretical manner. Then what happens to the decision which has been taken? And thirdly, now here comes the major suggestion. Today, you are saying that adjudicating authority, your approval does not matter. Whether you approve or not, our man will continue to act as AR and he will take all the calls. You take your own sweet time, you appoint after 6 months, we don't care. Is that the situation we are wanting? Then if that is the situation, then why can't you change the law and say, A will not appoint, let the class of creditors whom they have selected, he is appointed as an AR. Change the law then. Why do we need that? In fact, if you want real simplification, appointment of AR, why do we have to go back to the adjudicating authority at all? So my suggestion for simplification would be that if the home buyers or the class of creditors have selected one person who gets the maximum votes, let him start functioning as an AR, not as an interim AR. Let's change the law. Let us not go back to the adjudicating. Why do we need to go back to the adjudicating authority for that? So we can change that law itself. So I think that is one of the important things which are coming into it. I will open the discussion now to my friends for their comments. Yes, Mr. Parthasen. Sir, you need to unmute yourself.
Sir, actually, I don't have any suggestion, but I have an observation, sir.
Yes, sir.
Sir, if you see regulation 16A,
yes, sir.
2 said that the interim resolution professional shall apply to the adjudicating authority for the appointment of authorized representative selected
Correct.
by. Right. Then 3 said any delay in appointment of authorized representative for any class of creditor shall not affect the validity of any decision taken in the committee. by the committee. So does not it mean that regulation allow AIR to attend the meeting? Then why this is required?
That is not the intent, sir. 16A3 was brought in for a different purpose. Well, the purpose was this, that you see, AR is not being appointed because application is pending. In the meantime, COC meeting held, no AR is attending. But whether those actions will be valid or not, so regulation said actions will be valid, whether AR is there or not. He was not supposed to attend. That was very clear. No AR can attend without his appointment. So that was very clear, sir. 16A3 does not say that. Now they are saying he will be considered, because now they are adding a proviso, simply saying that he will be treated as an in interim. So he is considered as an interim AR nowadays. So there is a different connotation, sir. Okay. Yes, Mr. Narayan Kama, please go ahead.
Sir, I agree that the point of going to AA is what you call influxes in the current day. It only adds to the workload. One more IA, one more hearing, one more advocate to be appointed, all this. And at the end of the day, AA's position is very important, because in the first COC, if AA authorized representative is not available, the fact of appointment of RP itself is challenged. Suppose where the home buyers are holding majority, in this case the appointment, the AR cannot function, so the only financial creditors will have a say in appointment, because in the first COC the AR would never have got his appointment order, and in first COC we go and appoint the RP. That's a very important part. And it's better that judicial requirement, approval requiring for appointment of option should be done away instead of this proposed amendment.
Okay, great, sir. Great. We have heard that. I think that's a good suggestion. Yes, I think Mr. Panikar. Yes, sir.
Sir, I totally agree with your point with regard to the not to take up this matter with adjudicating authority. I'll explain another perspective. The CIRP, even though RP do not have an adjudicative role, he is just a collation, verification, all those things. But certain acts, only RP takes the responsibility. Meaning, you verify that plan is complying with 37, 38, 39, 40, whatever it is, and giving an affidavit in format. So he is taking the regulations and the section allows RP or empowers RP to take some responsibility. Therefore, when it comes to the appointment of AR, which is germinated from the public announcement, why can't RP give an affidavit along with the constitution of them and forget about this adjudicating process? In our case, where I've taken 3 months, it has gone. Luckily, that 3 months I used it for extension of the insolvency proceedings. That's a different story. But whenever you approach, I can say only mostly I have my presence in Kerala. I can imagine the cases in Mumbai or Delhi or Calcutta.
Sir, namaskara. Seem to be very busy.
Yeah, so I think we've got, I think, friends, may I request everyone to just please mute
yourself. When can I meet you, sir? I would like to ask.
Can I request organizers to mute the person concerned? Yeah, thank you. Thank you. Friends, my request is please remain muted unless you have to speak, because I think this may delay the whole discussion. Yes, sir, please go ahead and conclude, sir.
My view is, sir, during the CIRP proceedings, RP has the power or endowed with the power to take some critical decisions. And appointment of I don't think appointment of AR requires that sort of adjudication from the adjudicating.
The only point which comes to mind is, because as per if we read the regulation and read the law, is whether disciplinary cases are pending against him or not, whether AFA is valid. So I think these checks can also be seen by the RP. So RP can also, on the basis of the public domain and also based on the affidavit filed or the consent filed by the AR, I think he can also have to do that check. So I think most of us are agreeing that this should be done away with.
After the first COC meeting, anyway, RP has to go back to adjudicating authority. Let him give an affidavit also. Let him give an affidavit that he has produced all these AFA and all those things. Unnecessary it is. Of course, we will be.
Agreed, sir. Agreed. So the simplification would require, let us simplify it altogether. Let's not go to A at all, because in any case, what is the purpose of A? They are only putting they are only a stamp authority nowadays.
Absolutely.
He has already started functioning. What happens to his actions then? Will those actions be valid or not? So we are getting into more litigation actually with these. Okay, good point, sir. Yes, Mr. P.T. Joy and then Mr. Sanjay Borad. Yes.
Sir, as per the existing provisions, the AR should be appointed before the first COC, is it not?
Oh, that is a requirement, sir. But if the approval doesn't come, what do we do?
No, because they start saying that no, see, as per the existing provision, so and so, the financial, let us say the class of creditors, they are losing the opportunity of voting.
Correct.
Like the first COC can be held only after the appointment of Senate, theoretically.
No, I will not read like that. See, the only point is they should be appointed before the first COC, but it does not prohibit that you cannot hold a first COC meeting without the AR appointment. No, that is not the criteria. That is not the criteria because this is happening in many cases where AR appointment is delayed for 3 months. It doesn't mean that you're not going to hold the COC meetings for first 3 months. So I don't read like that. So therefore, they are saying that because in fact, in the discussion paper, they are saying RPs are holding COC meetings and the class of creditors are getting unrepresented. That is their point. So their point is that let's have an interim AR who will actually act, who will use all the powers and the duties of the normal AR till the time his appointment is confirmed. That is what they are trying to say. So they are typically saying adjudicating authority, you don't matter. They are typically saying your approval is only administrative, but we don't bother about your approval nowadays. Okay, yes, Mr. Sanjay Burad.
One word. See, even if the interim AR is replaced by another AR, no action done by the interim AR will be invalidated.
No, there can't be another AR, sir, because see, the point is, I have not seen a single case where a AR is selected by the class of creditors and rejected by the adjudicator. I have not seen a single case. If somebody is aware of that, please let us know. Okay. So typically speaking, there is no question of second AR being appointed, but there can be a circumstance in theory. In theory, there can be a circumstance that a second AR comes in place of the interim AR, then what happens? So whether these actions are valid or not, so I think we need that proviso also to that extent. Yes, Mr. Sanjay Burad, go ahead, sir.
So I am an AR in a particular case, and in my case, what happened? There were 2 ARs who got same number of votes. So then, then the RP went to adjudicating authority and then asked their view on that, and they appointed me out of.
Okay, good point, Mr.
This possibility is not taken care of. Talk about.
So in the normal circumstances also it is not taken around. And now in this case, who will act as an interim AR? Your good point. So whether both of them will act as interim AR in the meantime.
Precisely.
Good point, sir. Very good point. I think this needs to be clarified when you are amending Regulation 16A. I think they should also put in this clause that how to break this kind of equality, which if 2 people get equal votes. Good point, sir. Thank you. Yes, Mr. Partha Sen.
Sir, another observation from my side is that if AR is not appointed by the adjudicating authority, then how come his removal will be done by adjudicating authority? Then also it will be automatic. I mean, COC or I don't know. I mean.
Okay. See, as far as the removal of the AR is concerned, there is no provision in the IBC. But typically speaking, you see, there are judgments now which say that if the class of creditors are not happy with the AR, naturally they approach the NCLT under Section 60, subsection 5, because that is the omnibus section. And there are judgments, there are orders which have said to replace the AR. We have got those judgments also. So that is a separate issue altogether. We are only talking about the interim AR at this stage, whether he should act as a full AR with all powers and duties, or whether any approval of the AA is required or not. That was the moot question here, sir. So do you have any comments on this, sir?
No, actually, my comment is that, okay, I am not talking against appointing the interim AR, but the appointment of AR should be through NCLT. And that is only my comment.
No, AR, no. So let's understand. Once the AR is selected, naturally, application will be made. But while that application is being considered or pending before the adjudicating authority, there is a gap. Who is going to attend? So now IBBI says, despite the fact that application is pending, application is mandatory, but then this person will act as an interim AR. That is what the IPA says. So we are only saying we are seeing little potential legal challenges in this. Right. So that is what we have written on. Okay. So I think we have already commented that do away completely with the requirement of approval. So to make it more simplified, that is one. Now let us come down to the fourth suggestion, my dear friends, which is also very important. Of course, it does not affect the RPs that much, but it affects the personal guarantor. So here the stakeholders are personal guarantors. I think their view should be taken more than the RPs. But anyway, we are also competent. We can definitely do that. So current practice is that the IBBI discussion paper says that judicial authorities have issued multiple, sometimes contradictory orders regarding the treatment of guarantees in a resolution plan. Well, friends, let me give you a broad perspective. Some of the resolution plan says that the guarantees, personal guarantees, will also be deemed to be satisfied. So therefore, the financial creditors to whom the personal guarantees were given, they will not be proceeding with the personal guarantees. So this is exactly what has happened in some resolutions, and those resolutions have been approved also. So that is what, and some of the judgments say, no, we can't deal with the personal guarantee matters in the resolution plan. So there are some contradictory orders which IBBI is also referring to. So here they say that this has led to uncertainty about whether the approval of a resolution plan for a corporate debtor automatically releases its guarantors for liability. This is what their stand is, in the discussion paper. Let us look at what is the proposed amendment. Now they say to address the ambiguity, now we need to amend the CIRP regulations to clarify that a resolution plan does not extinguish the rights of creditors to proceed against the guarantors. So now they want to put in, a proviso in Regulation 37, which talks about the resolution plans, that the guarantees will remain valid. So let us look at, Lalit Kumar Jain, because they have said that Lalit Kumar Jain Union versus Union of India judgment has clarified. But I'm reading it little differently, right, than what IBBI is reading. I've just reproduced that paragraph. It says, in view of the above discussion, it is held that the approval of a resolution plan does not ipso facto, please underline the word ipso facto, discharge a personal guarantor of her or his liabilities under the contract of guarantee. As held by this court, the release or discharge of a principal borrower from the debt owed by its creditors by an involuntary process by operation of law due to liquidation or insolvency or approval of resolution plan, of course, does not absolve the surety guarantor of his or her liability which arises out of an independent contract. So Supreme Court is absolutely right. But they have not dealt with the subject. They have actually talking about in a general manner, looking of the contract, Indian Contract Act provisions, that whether, supposing a resolution plan is approved in case of a CD, whether personal guarantors also get discharged. Supreme Court says no. But now if you want to bring a specific provision that what is the specific provision they want to bring in? Look at this. They are trying to insert a new proviso in Regulation 37 Clause F, which says the reduction in payment of creditor. Clause F talks about reduction in payment of creditors, and then now a proviso is being added underneath, provided that a resolution plan shall not prevent the creditors from enforcing their rights against the guarantors of the corporate debtor. Now, friends, to my mind, what are the potential points of litigation? Let me tell you one or two issues which are there. Of course, they want clarity, they want consistency as per Lalit Kumar Jain, they want protection of creditors because creditors should not lose, the financial creditors particularly. Now, what are the issues which could be there? Number one, friends, the commercial wisdom of the COC now completely disappears, isn't it? Let me give you one very important case. I think because it has to be on a case-to-case basis, we can't generalize. In one of the cases, and some of you as RPs must be facing this issue. In one of the cases, the land, half of the land belonged to the corporate debtor, half of the land belonged to the promoters. And on the entire land, the factory building is constructed. So there is no diversity, there is no, you can say, division. It's a contiguous land. and on the contiguous land, you see continuous factory, you see building has been constructed. So it's very difficult. Today, if I need a resolution plan, I need to involve the promoters, because unless they give the approval, I can't include their land in my resolution plan. And without that, the factory land, factory building cannot be included. So nobody is going to file a resolution plan for that. So typically what happened, they approached the, you see, the resolution applicant, RA approached the, you see, promoter. They said, why don't you agree to give your land? He said, I will agree, provided you discharge me from my personal guarantor liabilities. It's always a give and take. I mean, he's also negotiating. It's a matter of negotiation, isn't it? So he negotiated, and the clause was put in that, look, they will stand discharged from the guarantee. And the commercial wisdom of the COC agreed with that, right? And when the COC agreed, so naturally the plan was approved, and then the NCLT, when they went to NCLT, naturally it is the commercial wisdom of COC. They can't impose their judicial wisdom in place of the commercial wisdom. The plan was also approved. But now I can see a potential difficulty. If I put this sentence, that means now the guarantors or the promoters will never be, you see, saying that we stand discharged. So why can't we leave it at the wisdom of commercial wisdom? But let me give you another point also. The second aspect is that supposing there are two financial creditors and the promoters have given guarantee to both the financial creditors. One financial creditor has 75% majority, the other has 25%. Now the person with the 75% approves that, but the 25% does not agree. So will his guarantee will also be discharged if it is mentioned in a resolution plan? So that means a majority can always bulldoze a minority, isn't it? That is also another second point which is there. So these are the two aspects which I wanted to bring in. I think I will open this for discussions one by one. Bharti ji, then Vikram ji, and then Shailesh Ojha ji. Yes, please, one by one, sir.
Yes, sir. I have a take on this, sir. Ki jab, according to our resolution plans, wherein the promoters can also be part of the resolution plan if it's an MSME. So in that case, if the promoter is not allowed to give away their guarantees, how will the person even put a resolution plan in place, even though he's allowed by the court or allowed by the regulation? It will be very difficult, because once he's even out of the regulation, out of the whole mess, his personal guarantee will still be stuck in the whole of the plan. I mean, that does not make any sense for this particular clause to be definitely there. I mean, it can be, it has to be on the option of the COC.
Right. I think, Bharti ji, your valid point, particularly in case of MSMEs. Nobody is going to come forward and say, why should I give a plan if you are not discharging me? And it's a private agreement between you and me, which is being reflected in a resolution plan. Resolution plan is also a contract. Supreme Court says it is also a contract between the parties.
Exactly. So and you cannot, the law cannot impose on the wisdom of the COC whether, and because it is very important and valid point when the resolution plan is given by the CD himself.
And I think what IBBI is reading in Lalit Kumar judgment, I'm not reading that. I put in before you, they are only making a general comment. That's all. That generally they will, if then they are saying does not ipso facto. That means as a matter of fact, they don't get discharged. But if your resolution plan says naturally they can get discharged because it's a contract again. So why we are doing that? Good point, man.
The moment their interest is satisfied, they will not, foresee that, enforce that guarantee.
Yeah. That is a separate issue. Whether they will enforce guarantee or not, but here now the IBBI wants, no, they can enforce. So tomorrow there is no guarantee, so they can come and enforce. So personal guarantor does not get a guarantee now.
Also, there can be two separate proposal, one for CIRP, and for the other part there has to be separate agreement between promoter and the creator.
But sir, the point is, why do we have to enter into so much of administrative thing when resolution
it's a
binding on all
when resolution plan is binding on
when resolution plan is binding on all stakeholders, let it be. Okay, yes, Mr. Vikram Kumar, I think you have been waiting patiently. Yes, Mr. Vikram Kumar, if you can hear us. Okay, Mr. Shailesh Ojha, you go now, sir.
Sir, in my view, they cannot be relieved from the guarantee.
They cannot?
मेरे कहने का मतलब है, मैं हिंदी में बोल सकता हूँ ना?
हाँ बिल्कुल सर, हिंदी इंग्लिश कुछ भी यूज करिए. I will translate, don't worry.
जी सर, ऐसा है कि मैं तो एक बैंकर रहा हूँ तो हमारी समझ से उनको गारंटी में छूट नहीं मिलनी चाहिए। इससे सबसे अधिक इफेक्ट कोई होगा तो जिसके पास सिक्योरिटी नहीं अवेलेबल है, अनसिक्योर्ड पोर्शन मैक्सिमम लॉस में रहेगा। इधर जो भी मैक्सिमम अच्छी रिकवरी जो भी हुई, तो पीजी को हम लोग जो दे जिसमें नोटिस, उसके चलते बहुत अच्छी रिकवरी हुई। तो इसको सीओसी के परमिशन से भी नहीं छोड़ा जाना चाहिए, अदरवाइज जो अनसिक्योर्ड पोर्शन है वो काफी अफेक्टेड होगा।
No, sir, there are two things. One is, you see, let us look at as a banker. Friends, what he's saying as a banker, he says, in his opinion, the COC or should not have power to discharge the guarantors from the personal guarantee. This is what his opinion is. Of course, he's supporting the proviso which is being added. But the only point, sir, which you have to consider, Mr. Sailesh Oja, is this. We gave you one example. Then that means the resolution plan fails in that situation. Number two, if the banker is agreeing to discharge, then what is the problem? Because ultimately the deed of guarantee is also, you see, a contract. So if the other party also agrees, okay, I will discharge you. So I don't think there should be any difficulty if that banker is also agreeing to whom the guarantee has been given. That is the second point. Third point, which is a very important point. As a banker, please, you have to answer this question. I have seen loans taken up to 500 or 600 crores by the corporate debtor, guaranteed by a personal guarantor whose assets are only 50 lakh of rupees. Tell me, can you recover 500 crores from a person of a net worth of 50 lakh of rupees? Were the bankers closing their eyes while taking their personal guarantees? And it is there in maximum cases. You go and look at any of the large, you see, buyer or a high net worth individual, his assets are typically less than what the guarantee is giving. So what do you propose to recover from him? Just 50 lakhs. If he is ready as an MSME, assuming he's giving you in that a resolution plan that I'm going to ready to make a payment, or he's surrendering his land, which is worth maybe 1 or 2 crore of rupees, I think you see this should go to the wisdom of the COC rather than putting a restriction there. Well, let's keep it open. Let's keep it flexible. Because if we go to the BLRC, what does it say? It is a matter of negotiation. So you're not allowing negotiation then. That is what the point is. Of course, your point is taken. Yes, Mr. Panikkar, I'm sorry. Yes.
Sir, if they are getting enough money for their personal guarantees, then they should release it.
No, whether they are getting money or not,
The
it's a
purpose is
commercial
only to reallocation.
No, that's what I'm saying. It is a personal call of the bankers only, na? Financial
Yes,
creditors to take. If they are agreeing to discharge, what is the problem with the IBBI? Why should they step in and say no, they will not stand discharged? This is what exactly we are discussing. Okay, yes, Mr. Pan, your views on this.
I have both of there were about 3 points which I want to discuss. 2 you have already discussed. Sir, can you please go to proposal, please?
Yes, I'll go to the proposal, sir. Yeah. Yes, sir. This is the proposal.
I don't know what government does. I mean, I'm sorry to use this. Provided that a resolution plan shall. How can somebody write like this? Even it is against the Contract Act. When every agreement enforceable by law is a contract, then if both the parties, creditor and debtor, decides to relinquish, then what is the problem with IBBI or the government? The word shall itself should be thrown away. At best, you can use the word may.
If we use may, then it has no meaning at all. So what they are intending is no, your plan will not discharge the rights of the guarantor. In any case, Supreme Court has clarified why the IBBI wants to bring in
This is a classic case of not appreciating the intent of code. It should not be used as a recovery mechanism. I agree with Shailesh, sir. It is not a recovery mechanism.
Right. Oh, I agree, sir. I agree. I think your point is well taken,
This
sir.
is a case of over-regulation, not a...
Yes, it's a case of over-regulation. Bilkul, absolutely. Yes,
it shall. And say that it is a recovery. It's not a recovery. It's a resolution.
True. Yes, Mr. Alan Bosco, please go ahead, sir. And then Mr. Girish.
Good evening, sir. So my point of view on this is that what IBBI has ended up doing is it has undone all the court judgments when it comes to release of personal guarantors. So right now they're saying that you cannot release a personal guarantor in a resolution plan.
Correct.
And I think what could have saved this amendment is to say that you cannot release you could have changed it to say that it does not prevent a dissenting financial creditor from enforcing their rights. I think this would have saved the entire intent that IBBI had. So I agree with your point where you say that if the creditor and the debtor agrees, why not release the guarantor? That is absolutely true.
Right.
But adding a clause that it will not affect a dissenting financial creditor will ensure that there is no cram down by.
Okay, got your point. So therefore, those people who are approving the resolution plan, we can say that they have consented to the plan and they are discharging. But those financial creditors who have voted against the resolution plan, then they should continue to proceed against the guarantor. That is what you are trying to say, sir?
Absolutely, sir. That makes sense because.
Good point, sir. Good point. Good point. I think that's a good point. Yes, Mr. Girish, and then we will go to Mr. Rajkamal. Yes.
Yeah, I think essentially it's the same point which Mr. Bosco has raised. I think as it is, the IBC allows initiation of CIRP against the personal guarantors, even if the CIRP against the CD is ongoing. So we can have two parallel CIRPs
Right.
with relation to the same CD, one against the CD itself and one against the personal guarantors. So I think the IBC allows that. So it is a discretion of the financial creditor whether they want to initiate some action, recovery action against the personal guarantor. They should leave it at that. And another point is, why would a resolution plan talk about the relieving personal guarantors? Because their concern is, I mean, they want to. It should be restricted to making the CD ongoing concern, correct?
No, actually, sir, there are certain situations like Bharti ji mentioned that in case of MSME, the promoters can submit their plan because 29A, C and H are not applicable. Now, while giving plan, naturally, they would like that we should be discharged from the guarantees.
But they can use that as a route to get themselves discharged. They can use it. No?
That's what I'm saying. So they can use this route. So therefore, in a resolution plan, they will put that clause for their own security and benefit, which is possible. And it has been done. It has been approved in many cases also.
But is it desirable, sir?
Yeah, it is. Yeah. Naturally, sir, let's understand in a broader manner. I think our concept should be clear. Let's talk about that. Why personal guarantors cases of insolvency resolution also come to NCLT, not to DRT? Please tell me what was the objective? Why did you see the central government bifurcated individuals into two parts on 23rd November 2017 itself? In the first amendment of by ordinance, the purpose was that look, the debt is same, the liability is same, because if the corporate debtor fails, then the personal guarantor is supposed to pay. They said if the CRP is going on, the case of personal guarantor should also be dealt by the same NCLT. That means, in fact, if you ask me, there should be a provision for a common resolution or stroke repayment plan. Why do you want two plans? Because if the same NCLT is dealing, their issues should also be taken care of in a resolution plan itself. So I don't foresee any problem, sir, where personal guarantors are discharged in a resolution plan. I think this is a benefit for the promoter. We are giving them an advantage. Come forward and pay your money. Get away with your personal guarantees also. I think that's a good message which we are giving to promoters. But today, if we restrict, then you're restricting the contract in India. So which is not permissible. But yes, we agree with Mr. Alan Bosco saying that the rights of the dissenting creditors or the who are voting against the resolution plan, they should be protected because their consent should not be taken that a resolution plan has been approved. So therefore, they will also not execute the invoke the personal guarantee. Or to that extent, I agree, sir. Okay. Yes. Yes, Mr. Rajkamal Saravu. Please go ahead, sir.
The point which I wanted to mention in the last, you have already mentioned that when the resolution is to be given, it is to be given taking into the guarantees given by the guarantors. It may be a corporate guarantee or it may be a personal guarantee. So either way, the solution should be in the resolution plan that it is a wholesome solution with the guarantee itself, along with the guarantee itself. Particularly the guarantee with regard to the present corporate debtor Other are not subject matter of this under the present CRP, but the solution for the guarantee for the guarantee for this corporate debtors should be dealt in this along with this CRP only. That should be the intent of the law. Or it may be an option that it might be proceeded with separately.
Correct. So all what we are saying is, naturally, if that corporate debtor plan is concerned, so it will talk about the guarantees given in respect of that corporate debtor. That is what you are trying to say. You are absolutely right. I think that is what is taken. Not for all guarantees all over the world which he has given. He will not stand discharge, right?
Yes.
Okay. So friends, these are the suggestions which we have got it. I would say that as far as personal guarantors cases are concerned, we need to consult the personal guarantors also, because their views are very, very important for that. So friends, I think we have already discussed, we have already debated all these aspects. So I think thank you so much. We have taken the first discussion paper. We have almost taken 2 hours on this because we needed a lot of this. There were only 4 amendments, but we took almost 2 hours. If the time permits and the organizers feel, we can go ahead for next 10-15 minutes to discuss the liquidation progress report also, because that's not a very big deal. Let me show on the screen. I think we can go ahead with that.
Yes,
so
yes.
let me share. Okay.
Sir, I'll take 1 minute to just announce.
Please go ahead.
Filled in the Google Sheet. May kindly fill the Google Sheet, because that will enable you to get the CPA credit. Google Sheet is already shared in the chat box. Thank you, sir. Thank you so much.
Yeah, CP hours are very important. So please follow the process, friends. Okay. So now let me see if I can open that. Okay. I think I'd opened that discussion paper. Let me see. Okay. Okay. I'm not able to share it. Let me try and once again. Yeah, okay. Now, can you see this document now? I believe you can, right? Okay.
Yes, we can see.
Yes. So, friends, this is a discussion paper which has been issued very recently on 21st January, which is the last week. Typically, because progress report has to be submitted by the liquidators during the liquidation, but there was no standardized format which was available. Of course, the regulation mentioned that you have to mention these items, but there was no standardization. So today, in fact, this was what was required to be mentioned. Look at this on your screen. These were the things which were to be mentioned: the appointment, tenure, cessations, settlements, the status of the property that remains to be sold, distribution of the unsold property, and all those aspects which were required to be mentioned. But there was no standardized format. So we are moving towards a standardized. This is what the intention is: standardized format. So the draft of the format, which runs into number of pages, which runs into almost 7 pages, friends. This is the annexure which I'm showing you. I can scroll through. We can discuss point by point if you wish to do that, or if you have any comments.
Sir, is it possible for you to enter with screen size?
Absolutely, sir. Absolutely. Let me do that, sir.
Oh, great. Perfect. This is better. Much better.
Is it much better? Okay. All of us are wearing, you see, high level glasses, so naturally we need bigger font. Okay, so details. First column talks about details of the corporate debtor, where they're talking about initiation of the liquidation, name of the liquidator, whether it is being maintained as a going concern, valuation during CIRP, valuation during liquidation, ICD, and the RPs with dates. So this is typically a general information which is to be stated. Friends, I have got only one issue. Of course, giving this can be because this is not an online form. This is to be submitted to the adjudicating authority. Naturally, a copy has to be given to the board also. But this is not auto population will not happen. So every quarter, my dear friends, a copy paste will happen in this particular thing. And if there are any changes, naturally those changes will have to be brought in, because this is the situation for every quarter. Then, of course, there's a synopsis. You have to mention about the brief facts about the case, including reasons for commencement of the liquidation process. So here, when the company came into CIRP, why it came into the CIRP, why it came into liquidation, some brief facts have to be stated in every status report. Then they are talking about the present status of the process. That means reasons for pendency and proposed line of action, and any important order from any authority other than adjudicating authority affecting the process. So this is the present status which needs to be given. So friends, if you have any comments on point number A, B, C, let's do it together. Let's not wait for the entire form to be seen.
I'm so sorry.
Yeah.
Those the important order for the authorities for the A affecting the process. We already have to submit to the IBBI all the orders now as per the new regulation and new amendment, that all the orders where he says the IBBI has listed the number of orders that needs to be uploaded every time when there is an order made. Again, in the process report, we have to again mention whatever the order has been made, and the copy of the order needs to be attached.
The answer is yes. But I would presume that it is between the last progress report and the next progress report. That is, it is for the quarter. So within that quarter, if you have received that particular order, I think that should be the intention. The orders which you have already submitted, attaching it with every status report, I think you are making it bulkier. And in any case, this status report originally has to be filed with the adjudicating authority. A copy has to go to the board. So board is not the main person. The main authority is the adjudicating authority. They naturally have their copies of their own orders with them. Why do they want orders from
Exactly.
the
They already have the copies that they have already given it to us. We again have to give it with the progress report that we
Right.
received it.
So good point.
Here, I think, sir, here they are asking
The
for
return other than AA.
other than AA, sir. These
Yeah.
have to be other than the
Outside AA.
adjudicating authority. These are not
Okay,
from
okay.
the orders of AA, sir. This should
From
be
any
other than
authority
AA.
other than. Okay, got
Sorry,
it, sir.
I missed that.
Got it. Thank you, Mr. Narayankama. I think you have pointed out very well. Okay. So point number D, list of events, actions during liquidation process in chronological order. First column says from liquidation commencement date to previous progress report, and second during the current quarter. So typically in every status report, this needs to be reproduced, and you will update, you will keep on updating from the last quarter to the next quarter also. And in supposing in the June quarter, you will include up to the March quarter, and then from March to June separately in column number 2. But when you reach the September stage, the first column will be up to the June, and the second will be from July to September. So this is the way. I think there should not be any problem. But yes, I would only say that it is kind of very repetitive, because every time, every quarter, this list is going to go long actually. The next one is point number E, talks about summary of receipts and payments during the quarter. I think this is essential, which is required as per regulation also. So I don't think I have any issues in any of the columns here. This in any case, liquidators will be maintaining. So they will have to inform.
Here, I think there is an annexure also to the same effect. We need to also.
Yeah, I'll come to that. I'm coming to that. Then non-fund based exposure of the banks during CIRP and liquidation process. Exposure at the beginning of the quarter, exposure at the end of the quarter, reasons for change. Any bankers who can, or any RPs who can explain how the non-fund based exposure will change during liquidation?
Yes, sir. So sometimes what happens is when there is an infra company, there are a lot of LCs or the BGs that are given to various authorities for taking the projects into hand. Sometimes they get devolved, sometimes they might not get devolved. Probably this is with respect to those non-fund based exposures of the bank.
No, Bharti, let's understand. Non-fund based exposure is whether devolved or not devolved. They are not talking about devolvement. They're saying what is your non-bank, non-fund based exposure? How many LCs you have given? How many guarantees you have given? Devolvement se nahi chal raha hai. So only thing is, yes, if it's a running concern, going concern, doing certain infrastructure project, there can be a change.
There
Yes,
can be a change.
I
That
agree.
is why this letter was there, I think.
Okay. Got it. Okay. So liquidation cost, naturally, liquidation cost, we don't have any issue in that. Distribution made to stakeholders, I think there should not be any problem, because they are talking about claims admitted during the quarter, total claim admitted, the amount distributed at the beginning, during the quarter, and cumulative. So I think I don't foresee any issue in this. But now come to this. These are very important ones. Annexures, constitution of the SCC, and there are A to I, 9 annexures are there, for which also the format is there. Let's go to the format straight away. So constitution of the SCC. So that is to be stated in every status report. Then SCC meetings. So they say date of the meeting held during the quarter. So if you hold 3 meetings in a quarter, so naturally for each meeting, you will have to give this table. So again, I don't foresee any issue in this. There is no repetition. Appointment cessation of professionals. Here they are not saying during the quarter. According to me, they should talk about during the quarter. Or if they are wanting the details of all professionals for all times, I think then that will become very repetitive. So maybe because it's a quarterly report.
Sir, intent is progress, so it has to be only for that particular quarter.
हाँ, that is true. But sir, क्या है ना, देखिए यहाँ पे क्या लिखा है? Details of the meeting held during the quarter. यहाँ पे कुछ नहीं लिखा. Quarter word is missing.
टाइप करना भूल गया था सर.
टाइप करना.
नहीं सर, ये बात नहीं है. एक्चुअली प्रोफेशनल्स जो होते हैं जनरली कंटिन्यू रहते हैं. दैट इज व्हाई दे मिस्ड इट हियर क्वार्टरली.
No, sir, continuation की बात नहीं है. यहाँ पे appointment की बात हो रही है. If you have appointed a new person, I should be giving that information in the next progress report. ना previous वाली की तो दे दी already, वो तो चल ही रहा है. अगर वो cease हुआ है, then I will write the date of cessation. So according to us, it should be only for during that quarter, not the all one. Then detail of the security interest realized or to be realized by each secured creditor. Naturally, this will. Yes, sir. Sorry, I'm sorry.
That C in that box C, the table C, instead of one additional column would suffice saying that whether it's continuing or not.
Okay.
Instead
but even that also, sir. See, the point is, if it talks about cessation, and naturally if he ceases during the quarter, I'll give that information. So that means he's not continuing. So why do I need to repeat? Supposing I've appointed, say, 7 professionals, and their appointment ceased in the last quarter itself. Do I have to give those details again?
In fact, I remember my case where this was a big table for me. I used to write every time a person comes and goes.
Right. So I think once you have given that in the first report, or previous quarter report, in the next quarter it should be progress. That is what we are trying to say. Okay. Then amount of security interest realized or to be realized, that is also there. Probably it is only for quarter. Then details of assets put up for sales during the current quarter. Look at this. Now they are using the word current quarter, but sometimes in some points they have missed it. Then they say not being put up for sale, assets not being put up for sale during the quarter. So again, this is for quarter. Then they are talking about details of PUF application. I don't know whether it is for quarter or they are wanting the details for all times to come. If it is for all times, then in every status report, I need to recapture that information all the time. But yes, present status can change. So therefore, status obviously we can change during the quarter. Then details of cases pending before courts or tribunals. So here they are wanting the complete details. Earlier they were wanting only the copies of those orders, but here they are wanting the all cases initiated by CD or against the CD. And look at the last one, friends, the receipts and payments. I don't know. Let me go back. In the form itself, there were receipts and payment already there. Look at this, receipts and payment account. But here on the top, it says summary, right? And you see, this is a summary of receipts and payments. But now at the end, they want a complete receipt and payment also. Probably, I don't know, it is also a summary, or they are wanting some details. So any comments on this? Why do we have 2 columns for receipt and payment? Why IBBI wants
maybe audited in a year? You have to do it once.
No, sir, this is not year, sir. It says at the beginning of the quarter, received during the quarter, at the end of the. So this is only a updation from previous quarter to this quarter.
Repetition.
And look at the previous one. So there are 2 receipts. Here they are saying summary. This is in a summarized form, right? And again, it says opening balance at the end of the previous quarter. Then at the beginning of the quarter, received during the quarter, at the end of the quarter, and then it's in a very generic way, right? Liquidator fee, liquidation process, miscellaneous expense, all those issues are there, from where the money is coming and where the money is going. But here they are wanting in little more detail that, again, in fact, if you ask me, it is like a summary only, isn't it?
Sir,
I think instead of left and right, they have made it
नहीं सर, it's seat and payment account हमेशा summary में ही होता है.
Some columns are new.
नहीं सर, फाइनल का अकाउंट जो भी होते हैं, सीट एंड पेमेंट अकाउंट कह लीजिए या इनकम एक्सपेंडिचर अकाउंट कर लीजिए, बैलेंस शीट कर लीजिए, वो समराइज फॉर्म में ही होता है. इट्स बेसिकली उन्होंने भी कोई कट एंड पेस्ट करके करा है. तो वी शुड रिकमेंड कि देयर शुड बी ओनली 1 सीट एंड पेमेंट अकाउंट.
Actually, if you ask
Is
me,
it possible that we
I
can
was
defer that the annexure, I mean,
नहीं सर,
over there,
काफी
annexure
इंफॉर्मेशन नीचे
now?
में डिटेल में है.
नहीं, अब जैसे
डिटेल मांगा है, ऊपर में
yeah,
समरी.
let's go one by one. Look at this. Like it says liquidation process expenses, right?
Yeah.
So this is like and then liquidator fee separate. But let us go down below. Let us look at the this portion. Now here they say liquidation process cost. They have now given the liquidator fees, support service fee, marketing fees, litigation. So now there's a breakup is also there.
Yeah.
So typically that is a summary, and this is a little more detailed kind of a thing. But दो बार देने का purpose नहीं है ना सर. आप उसी में वहीं पर ही expand कर दो ना. What is the purpose of giving twice?
In detail,
Or else we could have also said that as per the annexure attached.
सर ऊपर में बैलेंस शीट है, नीचे में शेड्यूल है.
सर ये शेड्यूल नहीं है, शेड्यूल नहीं है, ये समराइज्ड है.
Yeah, it's a summary.
And in nutshell, we can,
interpretation.
sir, in nutshell, we can say कि it should be one only.
हाँ, it should be one. Maybe you can combine. या तो annexure में डाल दो या ऊपर डाल दो, whatever you want.
We should give an outcome.
ये मैजिक करने तो ठीक है.
Right. Because you see, once you start filling these two this thing, maybe आपको बाद में पता चलेगा there are certain discrepancies which are coming in, isn't it?
So, sir, I think in the main form it also includes the unpaid cost. It talks about the total cost, and in the annexure they just talk about whatever has come and whatever has been paid. I think that is the difference.
नहीं सर, दोनों ही केस फ्लो है, रिसीट एंड पेमेंट.
दोनों केस में यही है सर. आप देखिए ना, एट द बिगिनिंग ऑफ द क्वार्टर
नहीं, कहीं अनपेड भी लिखा हुआ है.
अनपेड सर, अनपेड का वो एस्टिमेटेड का है, वो अलग कॉलम है सर. वो अलग है. देखिए यहाँ पे ये लिक्विडेशन कॉस्ट में लिखा है. एस्टिमेटेड कॉस्ट, एक्चुअल लिक्विडेशन कॉस्ट, चेंजेस इफ एनी, एंड फॉर एक्चुअल कॉस्ट एक्सीडिंग.
Actually, it's redundant. Only one is needed. That summary can additional benefit from preparing a summary other than an XPR or something very.
And look at the last note. I think Mr. Prasenjit, can you just mute yourself? Okay. Look at the note. Additional heads may be added based on the nature of the case. So you can expand this also. So when you
can we do this? Can we do this? Can we write it that's the annexure this, and then expand according to whatever the annexure is and give away with the annexure?
Well, all I think most of us are saying it should be at one place. That's all. That is the only intention, isn't it? So it should not be repetitive. It should be only at one place. If you want a detailed, you put a detailed format. If you want summary, put a summary only. In fact, if you ask my opinion, I think I can request organizers to please mute organizers are hearing me. Can Mr. Prasenjit can be muted, please? Yeah, thank you. So all I'm saying is that, look, in fact, in the last webinar also I said why the IBBI is concerned or adjudicating authority is concerned with the transactions. Going into the details, I think they should be concerned with high-level summaries. Typically, you see, you must have seen the cases. Let us talk about that. You file a status report or a progress report. Tell me whether any adjudicating authority goes into the details of that. How do they dispose of the application? Status report.
Sometimes I have seen progress report being really
taken on record.
No. Sometimes they are discussed at length, sir. I have seen few cases.
Okay. Maybe
in our case, it is simply, sir, taken on record.
Taken on record. Maximum 99% of cases are like that. 99% cases are like that.
Agree.
In some cases, they ask for the progress during the quarter.
No, that's all right. A progress report means only progress during the quarter only. So now there it is standardized format. So we are trying to say why you are duplicating the pieces. So I think that is the point which we wanted to say. There is nothing more than that in the form. So friends, any more comments on the first discussion paper, second discussion paper, last opportunity, though we have exceeded our time, so I have 12 minutes right now, but I think I can request the organizers for another 5 minutes. To go ahead.
I have a simple one suggestion.
Yes, sir.
Regarding the first discussion paper, that appointment of.
Can you identify yourself, sir?
Yeah, I am CS Sushil Agarwal, sir.
Oh yeah, Sushil ji. Please go ahead, sir.
Sir, in this particular language of the regulation, appointment of registered valuer to determine the fair value and liquidation value of the corporate debtor की जगह assets of the corporate debtor होना चाहिए. ये always missing है यहाँ पर, because if you align it with the valuation rules talks about company as a whole, whether liability is there or not. But generally, as
understood, sir. It is not typically the value of the CD. It is the value of typically the assets of the CD. Okay. Yeah, your point is taken, sir. Yes. Anyone else who wants to make a comment? Final? Yes, Mr. Harish. Yes.
So there is a notification.
Sir, why are you coming from Bharti Daga?
Sir, 22nd February, sir.
No, your name is appearing as Bharti Daga.
Yes, sir. I'm surprised.
Sir, I think you guys have shared the link with each other, I believe.
Yes.
Bharti ma'am has shared
Somebody messaged in the group, in the transition group, they are not able to join. So I said, let me put the.
Okay, no, doesn't matter. I'm just in a lighter vein, ma'am. थोड़ा सा atmosphere भी light करना पड़ता ना.
Even I am surprised to see.
Double CP मिलेगा, ma'am.
22nd February 2024, IBBI given on circular.
Yeah, yes.
That means when we file for the liquid dissolution of a company, no need of furnishing of the quarterly reports.
Right.
So with the circular, I think from the June onwards, where the cases already filed for liquidation need not bother about the new format, no, sir?
Absolutely not, sir. Because you see, the point is where you have completed the liquidation, you have filed a final dissolution for application with the final report. Because you see, there is a difference. There is a progress report, then there is a final report. So in final report means after that, there will not be any report. So this progress report is only when you are continuing with the liquidation. If you have moved the dissolution application, then it is not required at all.
Okay.
Yeah. Okay. Friends, anything you want to say?
Another point, everywhere, whether it is a liquidation cost or CIRP fee, RP fees, they have, made a minimum amount, they have, already provided. For valuation also, they should fix an amount.
For valuation, they should fix an amount.
Minimum fees तय कर दे सर, क्योंकि उसी हिसाब से क्या होता है, there will be, assignment can be given like that. Otherwise, today it has become like, fish market.
Okay, I think that's not a scope here, but your point is good. I think whenever they issue a discussion paper on valuation, probably this point can be taken across. All right. Okay. So friends, I think we are at the end of the session.
Yes,
it has been
appointing a single valuer instead of two valuers, my view is past mistake, they rectified it. Only one insolvency professional, only one auditor, why two valuer required? Maybe.
Okay. So you are supporting the
supporting the first value.
No, but Mr. Harish, let us understand. They are only providing for MSME or assets based less than 1,000 CR. So they are not changed the provision. The only thing is they are only relaxing it for some categories of the CDs. So to say that they have rectified their original mistake, they have not. And I don't know whether that was a mistake, because at the end of the day, look, if the asset base is more, you need more people, because one person can make a mistake. RP is fine. RPs are working in a different atmosphere, but valuation is more subjective. And when the subjectivity comes, naturally you need two opinions. When you go for a surgery, sir, do you consult only one doctor, or you take a second opinion also or not? So therefore, whenever it's a subjective thing. So when you are going on a subjective thing, naturally two heads are always better than one. But anyhow, I think we have already.
Just giving that.
Last question. We have to conclude. Last question.
Yeah, last question.
I was just saying that giving the sword in the hands of the COC is very difficult to appoint the valuers. Currently, the appointment is basis the RP's prerogative, not the COC's prerogative. Now we are giving the ball in the court of the COC.
Yeah, that we have already discussed. We have already noted that point. So we'll take that forward to IBBI. So I think I must now thank the organizers, and I must hand over back the proceedings for their closing remarks. My job is over, sir, now.
Thank you very much, sir.
Excellent session, sir. Thank you so much for the session.